On March 2nd, 2023, Alex Murdaugh was found guilty of murdering his wife and youngest son.
Alec murdered Maggie and Paul, that he was the storm.
And I could see his brain on.
It is our honor to represent Alec Murdaugh.
Generating millions of dollars in fees, that was not enough for you.
I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you.
This is Alec Murdaugh.
All these people on these two exhibits, these were real people that needed this money, is that correct?
I'm sure they did.
When the storm arrived on June 7th, 2021, that they died as a result.
After failing to get a new trial, Alex Murdaugh filed his appeal brief on December 10th, 2024. We've been waiting for 8 months for this reply. An extension was requested and granted twice, but finally, it's here, and not a single word disappoints. Join me while I dissect every one of its long-awaited 182 pages. In Part 1, we're going to review the statement of the case and the statement of facts. They read like a fine documentary and are the perfect review of the case. It's been over 2 years since justice was served in the murders of Maggie and Paul Murdaugh at the hands of their husband and father, Alex Murdaugh. Many have forgotten the facts that led to his guilty verdict, either through the passing of time or the propaganda put out by Alex's legal team and his questionable supporters who twist facts, defy logic, and even just make stuff up. Let's get started. I'm Cassidy O'Connell, and this is State's Reply, Upholding the Verdict of Guilty Alex Murdaugh, Part 1, Reviewing the Facts. Welcome. I thought I was going to have to write a review of this case to serve as a refresher of what happened during this trial. The statement of the case and statement of facts are so well written, I wouldn't change a word. So today, we're going through them because I can't think of a better way to accomplish this review. I'll bring it to life even more with pictures and clips. So sit back, relax, and let the words of our favorite South Carolina prosecutor, Assistant Attorney General Creighton Waters, wash over us. Statement of the case. In July of 2022, the Colleton County Grand Jury indicted appellant Richard Alexander Murdaugh, a disgraced former lawyer, for 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime in connection to the June 2021 slayings of his wife, Margaret Kennedy Brandstetter Murdaugh, or Maggie, and his youngest son, Paul Terry Murdaugh. At the time he was indicted, appellant was already in pretrial custody as the result of an earlier arrest. He remained in custody after the indictments were issued. On January 23, 2023, a jury trial was commenced in the Colleton County Court of General Sessions with the Honorable Clifton Newman, Circuit Court Judge, presiding. Footnote reads, by the time of trial, appellant had 99 other pending criminal charges. At the conclusion of the 6-week trial, the jury convicted appellant as indicted. Following the verdict, Judge Newman sentenced appellant to 2 consecutive terms of imprisonment of life without parole for the murder convictions. Footnote reads, because appellant was sentenced to life for the murders, Judge Newman correctly did not impose sentences for the possession of a weapon during the commission of a violent crime convictions. Appellant then timely filed a notice of appeal. During the pendency of that appeal, appellant submitted a motion to the Court of Appeals seeking for the appeal to be suspended and for him to be granted permission to file a motion for a new trial based on after-discovered evidence in the Circuit Court. On October 17, 2023, the Court of Appeals issued an order granting appellant's motion, holding the appeal in abeyance and remanding the matter to the Circuit Court. Following the issuance of that order, appellant filed a motion for a new trial in the Colleton County of General Sessions. On December 18, 2023, the Supreme Court issued an order assigning exclusive jurisdiction over the matter to the Honorable Jean Hofer Toll, retired Chief Justice. Following briefing the parties, Justice Toll conducted an evidentiary hearing in part on January 26, 2024, and in part on January 29, 2024, in the Richland County Court of General Sessions. At the conclusion of the hearing, Justice Toll orally denied appellant's new trial motion, and she subsequently memorialized her ruling through a written order filed with the Supreme Court on April 4, 2024. Again, appellant timely filed a notice of appeal. On August 13, 2024, the Supreme Court issued separate orders certifying both appellant's pending appeals pursuant to Rule 204B of the South Carolina Appellate Court Rules. Thereafter, on September 13, 2024, the Supreme Court consolidated both appellant's appeals. Statement of facts. In the eyes of most, appellant was a very successful man. He appeared to be a loving husband and loving father with a loving family. He was a longtime partner at Peters, Murdaugh, Parker, Eltsroth, and Dietrich, PMP-ED, a law firm that was founded in 1910 by his great-grandfather that bore the name of the prominent family of which appellant was a scion. He had a big reputation and was trusted, respected, and thought highly of by others. To many, he was an excellent attorney skilled at reading people and building trust and rapport. For a time, he served as the president of the South Carolina Association for Justice, making him a leading voice for plaintiffs' attorneys in the state. His practice was lucrative, and he sometimes earned over $1 million in a single year's December annual bonus. As expected with such earnings, he also seemed wealthy, and he owned multiple properties, including a beach house in Edisto and a 1,700-acre hunting estate called Moselle, that were quite valuable. In addition to that, he was a badge-carrying volunteer assistant solicitor at the same office at which his great-grandfather, grandfather, and father had served in the circuit solicitor role for decades. Appellant was very privileged, and his family legacy was of prime importance to him. Unfortunately, the reality of appellant's situation was far different from what it seemed, and this reality was a gathering storm that led to the murders of Maggie and Paul on June 7, 2021. Contrary to appearances, appellant was not truly doing well financially despite his considerable earnings. His financial troubles began in 2008 or 2009 due to an unsuccessful real estate venture in which he participated. Although he was involved in some large cases that generated significant income after that, it was not enough to remedy appellant's issues, and he wound up in substantial debt. Around 2011, appellant responded to his financial stressors by stealing from his clients and law firm, and he continued to do so on a routine basis for years, illicitly taking millions that did not belong to him, on top of continuing to borrow heavily from Palmetto State Bank and other institutions, while still making a considerable legitimate income. But his financial woes nevertheless persisted due to the costs of servicing the large debt load he had accrued, coupled with the costs of the lifestyle to which he and his family was accustomed. From there, appellant's problems only escalated. In February of 2019, his son Paul was involved in a fatal boat crash that resulted in the tragic death of a young woman named Mallory Beach. As a result of the wreck, Paul was criminally charged, and an investigation was eventually initiated into appellant's conduct on the night of the incident. Furthermore, in March of 2019, appellant, amongst others, was sued. Through that lawsuit, the Beach family sought $10 million from appellant personally, and their counsel, Mark Tinsley Esquire, suggested a transfer of ownership of appellant's beach house and hunting estate as a potential way to pay a portion of the demanded damages. Making matters worse, appellant no longer had a multi-million-dollar umbrella insurance policy to provide him with coverage in the boat wreck case, because the insurer had canceled the policy after paying millions for claims made in connection to the February 2018 death of his longtime housekeeper, Gloria Satterfield, following a fall at his home. Appellant had directed the initiation of a civil action for the benefit of Gloria's surviving children, in which he was the defendant, after promising to the children to take care of you boys. Appellant then stole millions from the case's proceeds without paying the surviving children one thin dime. and appellant did so despite falsely claiming to Michael or Tony Satterfield, one of Gloria's sons, he was only insured in the amount of $505,000 and would be working to get $100,000 each for Satterfield and his brother from the supposedly limited insurance coverage available. However, by April of 2021, Satterfield was asking appellant how the case related to his mother's death was going, as he had been doing every few months based on appellant's assurances concerning a potential recovery. Appellant, who had already received and stolen the insurance proceeds for himself, responded by falsely claiming the case was going well, but there was still a ways to go. Also around that time, the litigation related to the boat wreck remained ongoing, and efforts at mediation had failed to result in a successful settlement. Appellant claimed the most he could cobble together to resolve the matter was perhaps $1 million, due to his poor financial situation, while Tinsley, incredulous of that claim, continued to insist appellant would need to pay 10 times that amount. Due to the stalemate, Tinsley had filed a motion to compel, through which he sought records from all appellant's financial accounts, including his accounts at Bank of America and Palmetto State Bank. Ultimately, Tinsley's motion for appellant to have to open his books was set to be heard in court on June 10th, 2021. And here I feel I must add that the murder took place 3 days before this date. Compounding appellant's problems even more, around May of 2021, Jeannie Seckinger, a certified public accountant serving as the chief financial and operating officer at PMPED, discovered an issue with a disbursement in one of appellant's cases called Hirschberger. Approximately $83,000 in earned attorney's fees belonging to the firm had seemingly been disbursed, with appellant's approval, to Forge Consulting, a company that, amongst other things, assisted in planning structured annuities for case proceeds and attorney fees. Not yet realizing the money had actually been deposited into a fake Forge account appellant had opened at Bank of America to further his financial crimes. Footnote reads, again, Bank of America was one of the banks from which Tinsley was seeking appellant's financial account information in the boat wreck litigation. I'm adding again, in other words, this fake Forge account would have become known to the court. Seckinger went to discuss the matter with appellant because she believed he was honestly, but improperly, attempting to set up a structured annuity with the earned fees. Appellant responded by claiming he was simply trying to get money into Maggie's name due to the pending boat wreck lawsuit. However, appellant had secretly stolen that money too. That same month, Paul, who was called Little Detective by Maggie due to his efforts to make sure appellant was behaving, texted appellant that they needed to talk because Maggie had found several bags of pills in appellant's computer bag. In the past, Paul had at various points found pills in the home, and both he and Maggie were concerned about appellant's drug usage. Around the same time, Maggie conducted internet searches in an attempt to identify unknown pills by their markings. Another aspect of the gathering storm occurred in May of 2021 when Annette Griswold, appellant's paralegal, alerted Seckinger of an issue in the Ferris case, another of appellant's cases that was being handled along with an attorney outside the firm named Chris Wilson, Esquire. The footnote reads, at least at the time, Wilson was one of appellant's closest friends and had been so for years. Griswold told Seckinger she had only received the expense checks from Wilson's firm in Ferris, even though it was customary for expense checks and fees checks to be distributed at the same time. Before speaking with Seckinger, Griswold had spoken with appellant, and he denied having received the fees, which totaled $792,000. However, staff at Wilson's firm insisted appellant had received them. Indeed, appellant had. He stole that money too, after tricking Wilson into issuing the fees checks in his name instead of in the name of PMPED. Appellant deposited the first check of the $792,000 in early March of 2021, and appellant had exhausted every bit of the stolen fees just over 2 months later by May 25, 2021. As of June 2, 2021, the firm remained completely unable to obtain a satisfactory explanation from appellant about the missing Ferris fees. and they had also been unable to obtain the related disbursement paperwork from Wilson's firm despite their requests for it. However, shortly after Griswold sent yet another request for the information, appellant, who had been alerted of that request by Wilson, went to Seckinger and falsely assured her the fees were still in Wilson's trust account. I'm adding here, this is 5 days before the murder. He further questioned why she needed the disbursement paperwork at all. Uncoincidentally, around that same time, appellant asked his friend Russell Lafitte, the chief executive officer at Palmetto State Bank, how quickly one of his lines of credit at the bank could be extended by $600,000. By Monday, June 7, 2021, the day of the murders, Seckinger and the firm still had not received a satisfactory answer about where the fees in the Ferris case actually were, and she went to confront appellant about the matter that afternoon. Footnote reads, the confrontation occurred in the afternoon because appellant did not arrive for work that day until 12:24 p.m. When she approached, appellant gave her a dirty look and appeared disgusted to see her. Nevertheless, they met in his office privately, and Seckinger demanded proof he had not personally received the Ferris fees as she suspected. In response, appellant claimed falsely, the money was still in Wilson's trust account and could be obtained by the firm at any time. Appellant further explained he was just temporarily leaving it where it was because he was attempting to decide what to do to get more money into Maggie's name. As the confrontation continued, appellant received a call about his father, Randolph Murdaugh III. Randolph, who was suffering from cancer, had been taken to the hospital that day, and appellant alerted Seckinger there was nothing more that could be done for him. Footnote reads, appellant and his father would co-sign large loans, and Randolph also loaned large sums to appellant. Based on that, Seckinger quickly ceased inquiring about the missing fees, and thinking appellant was going to head to the hospital to be with his father, left appellant's office. However, appellant did not go anywhere. Instead, he remained working on a financial statement for the boat wreck motion hearing concerning his finances that was by that point just days away. Thus, on June 7th, 2021, the gathering storm of appellant's self-created problems was coming to a head, and the already immense pressure upon him was continuing to mount. Despite all his stealing, appellant was still millions of dollars in debt. He had limited funds available to him in his various accounts. Footnote reads, by August 6, 2021, the balance in one of appellant's checking accounts dipped to negative $347,784.67, and he had nearly completely maxed out 1,600,000 lines of credit, among other debts. Although he had stolen millions from his clients and firm, he had rapidly burned through the money he was stealing, sometimes in a matter of just weeks. Meanwhile, the Moselle estate was entirely in Maggie's name, and Maggie had a 50% ownership stake in the Edisto Beach House, which meant none of the equity those properties possessed could be utilized by appellant without Maggie's knowledge or involvement if she remained alive. Footnote reads, around that time, Maggie appeared to have no idea about the true state of the family's financial situation since she was actively shopping for a new house in Hilton Head. However, she was concerned about the amount of money being requested in the boat wreck lawsuit and was also anxious because she did not believe appellant was being truthful with her about the matter. By that point, appellant simply did not have the money he needed to pay back what he needed to be able to quickly pay back in order to delay or prevent his misconduct from coming to light. Footnote reads, in an earlier incident from 2018, in which the firm discovered appellant essentially cashed the same check twice for a single loan repayment that was erroneously issued to him instead of his brother, appellant, once caught, quickly paid back the money he had taken with interest while claiming he simply made an honest mistake. Due to the trust his coworkers had in him at the time, that proved to be sufficient to resolve the matter and stop any adverse actions from being taken against him. Back to the document, including the Ferris fees that he was confronted about yet again that very day. The stolen Hirschberger funds that were brought up to him only a few weeks earlier, or even the limited proceeds he'd been discussing with Satterfield as recently as April. And Appellant certainly could not afford to have his account information and true financial situation exposed in the boat wreck case, since his rampant stealing would have been readily apparent if the information was disclosed to anyone, including even just his own counsel, as a result of the upcoming hearing scheduled to take place that week. All in all, appellant was caught in a dangerous tangled web of his own making, and he was well aware of it. Just as it appeared, appellant was running out of options to keep his years and years of criminal financial misconduct hidden from exposure, Maggie and Paul were brutally slain at the kennels situated near the family home at Moselle. That occurred on the night of June 7, 2021, and significantly, those murders immediately put a stop to the gathering storm at appellant's doorstep. Paul was shot twice with a 12-gauge shotgun. The first shot, a non-fatal one, resulted in buckshot pellets entering the left side of his chest and traveling through his left arm, which notably was down by his side. Tragically, the second shot, a fatal one, resulted in birdshot pellets striking his left shoulder, entering his neck and face, and causing his brain to eject the top right of his skull. As a result of the second shot, Paul was immediately and obviously killed. His body dropped to the ground face down right outside the door to the kennel's feed room. Notably, Paul had no signs of any defensive wounds. Footnote reads, based on Paul's arm being down at his side when he was first shot, coupled with the total absence of any defense wounds, it appeared Paul was not expecting what happened to occur and was either real comfortable with or completely surprised by the shooter. That fact was particularly significant because, with both multiple dogs and guard birds down at the kennel, it seemed highly unlikely a stranger would have been able to sneak up on Paul without Paul being alerted by at least one of the animals present. Indeed, in appellant's own words, the family's guinea fowl just make a lot of racket any time anything unusual is going on. If anything disturbs them, could be a person, it could be somebody driving up, whatever, they're going to make a lot of racket. Back to the document. And stippling was present on his first wound, suggesting the shooter was no more than a few feet away when it was inflicted. Meanwhile, Maggie was shot and killed with a rifle loaded with .300 blackout ammunition. 2 of Maggie's gunshot wounds had parallel trajectories, with one entering below her ribcage near the middle of her body and exiting out her back, and the other traveling through her left thigh. Based on the stippling present, both those wounds were inflicted from close range, and the gunshots that caused them appeared to have come from the direction of the feed room where Paul was killed. Maggie also had a gunshot wound to her wrist, which could have been caused by one of the other shots. Another bullet, likely fired while Maggie was bent over in pain from the abdominal wound, traveled in an upward direction through Maggie's body, pierced her left breast, and entered her face and head, basically destroying the brain. That wound was immediately fatal. In addition to that, Maggie was also shot in the back of the head, near the base of her skull, and the bullet traveled through her brainstem with a downward trajectory. Like Paul, Maggie also had no defensive wounds, and her injuries were plainly incompatible with life. As would later be discovered, Paul's iPhone, which was consistently being used up to that point, as was typical for Paul, locked that night at 8:49:01 p.m. and remained locked until its battery died a little less than 2 hours later. Around the same time, Paul suddenly and completely ceased responding to all calls and texts, even though he was actively engaged in ongoing communications with others, including his friend Rogan Gibson, right until his phone finally locked. 30 seconds after Paul's phone locked, Maggie's iPhone did too, and it remained locked until it was recovered along the side of the road near Moselle the next day. Footnote reads, on the afternoon of June 8, 2021, Maggie's phone, which was not at the crime scene after the murders, was recovered roughly 15 to 20 feet away from the roadway at a point roughly 1/2 mile or so from the entrance to the Moselle barn area. Investigators were able to track the phone's location by using the Find My application on appellant's surviving son's phone. Like Paul, Maggie also stopped answering calls or responding to texts after her phone locked that final time. Just moments before their phones locked for the last times ever during their lifetimes, Paul and Maggie had both been down at the kennels where they were murdered. And they were not there alone. Contrary to what he would later claim over and over again to investigators, family members, law partners, friends, and anyone else who would listen, Appellant was down at the kennels that night too, right along with Maggie and Paul in their final moments alive. Appellant was known as a prolific and even obnoxious user of his phone. However, his iPhone reflected no signs of activity from 8:09 p.m. until approximately 9:02 p.m., when it suddenly sprang to life and began recording a flurry of movement, including an uncharacteristic 283 steps in just 4 minutes. At 9:04 p.m., Appellant called Maggie, who did not answer, and then called his father a little less than a minute after that. Appellant then called for 3 seconds Maggie, again at 9:06:14 p.m., and notably, Maggie's phone orientation changed just 2 seconds before that unanswered call came in, suggesting someone was holding the phone at that time. After that, Appellant got into his vehicle, and he called Maggie another time at 9:06:52 p.m., again receiving no answer. Despite calling Maggie 3 times in a span of just a few minutes without answer, Appellant began driving toward his parents' house at Alameda without making a quick stop by using the driveway to the kennels on the way, which, according to at least one of Paul's friends, Appellant would typically do when he knew a family member was down there. Making that decision even stranger, Appellant, despite later claiming something to the contrary, has specifically asked Maggie to come from Edisto to Moselle that night for the purpose of visiting his parents. Footnote reads, Appellant also asked Paul to come home that day, according to Maggie. Not long after he left, and approximately 16 seconds after he passed the spot where Maggie's phone was later found along the side of the road the next day, Appellant sent a text message to Maggie's number indicating he was going to Alameda to check on his mother, who was suffering from Alzheimer's disease. Following that, Appellant placed calls to his son Buster Murdaugh, one of his brothers, and Wilson, and he also received a call from Wilson as he continued on to Alameda. All those calls were relatively brief, with the longest lasting just over 2 minutes. Appellant arrived at Alameda and he parked his vehicle way in the back near a wooded area and shed. Footnote reads, on his nighttime drive to Alameda, Appellant reached a peak speed of 74.4 miles per hour. Similarly, later on his return drive, Appellant's speed peaked at 80.16 miles per hour. Meanwhile, the highest posted speed limit along Appellant's route was 55 miles per hour. Notably, the dark rural roads involved were such that one officer testified he would not even run code at those speeds at night on that route. A little over a minute later, Appellant called his mother's number to announce his arrival. However, Appellant was still outside for roughly 5 more minutes after calling, and during that period, another flurry of steps was recorded on his phone. Footnote reads, around the time Appellant was supposedly visiting with his mother, several system startups were also logged in Appellant's vehicle data, which could be triggered by the vehicle's doors or rear hatch being opened and possibly by someone walking near the vehicle while in possession of the keyless fob. Eventually, though, Appellant went into the residence, and he remained at Alameda for just a few minutes before returning to his vehicle. At 9:43:18, Appellant began driving away and heading back toward Moselle, but as he was leaving the property, he stopped and parked for nearly a minute. After that, he resumed his drive home. Along his way, Appellant called Maggie and then Paul, receiving no answers. He then quickly sent a text message to Maggie's number requesting she call him. Following that, Appellant sent a message to Wilson asking him to call, and Wilson did so twice, resulting in 2 brief conversations. Appellant arrived at Moselle right around 10 p.m., and he headed straight to the house. He remained there for roughly 5 minutes, and while there, he called Maggie's number yet again. Then, at approximately 10:05 p.m., he began driving toward the kennels. At approximately 10:06:14 p.m. that night, Appellant called 911. Based on Appellant's vehicle's records, That call was placed a little less than 20 seconds after he arrived at the kennels. Despite the short time between arriving and calling, appellant reported he saw his wife and child had been shot badly. Neither were breathing, and he had already been over to them and touched their bodies to check on them. In addition to that, appellant told the dispatcher he had last talked to Maggie in person approximately 1.5 to 2 hours earlier, and he quickly brought up the boat wreck as a potential reason for the shootings. Furthermore, he asserted he was heading back home to get a gun, and his vehicle's data reflected a quick trip to the house was made. Following that, appellant ended the 911 call at 10:17 p.m., stating he needed to contact his family, and with his slain wife and child just a few feet away, he began placing call after call, including multiple to Paul's friend Gibson. Notably, Gibson had repeatedly called and texted Paul after Paul failed to respond to a text sent at 8:49:35 p.m., and Gibson's last attempted communication that night occurred at 10:08:27 p.m. Beginning at 10:21 p.m., appellant, who picked up Paul's phone after Paul was killed, and thus could have seen the missed calls and text on its screen, footnote reads, at 10:20:08, Paul's phone registered an auto lock, which could occur when the phone's facial recognition feature failed to recognize the face of the individual viewing the phone's screen. Repeatedly attempted to contact Gibson, placing 4 calls and sending 1 text message in a span of less than 10 minutes. Footnote reads, notably, appellant's first attempt to contact his surviving son Buster did not occur until 10:44 p.m., which was well after appellant had tried to contact Gibson. And that brings us to the end of Part 1. Part 2 coming soon.